John Kennedy builds traps the way a lawyer builds a case. Not with accusations delivered at volume, but with premises established quietly, each one confirmed before the next is introduced, until the structure assembled in the room becomes impossible to dismiss. What he brought to that hearing was a sequence. A judge in Wisconsin who broke federal law and was arrested. 2 senior FBI officials who also broke the law, or something close enough to it, and were paid $2 million. A laptop that sat in FBI possession for 10 months while the public was told it was Russian disinformation. And then at the end, the question nobody had prepared for. Did Jeffrey Epstein hang himself, or did somebody kill him? Each element was connected to the same underlying question. Not a policy question. Not a budget question. The question of whether the law applies equally to everyone, or whether proximity to power creates a different category of consequence. Kennedy started with equal treatment. He asked Patel about the Wisconsin judge, a state court judge who had been arrested for helping an undocumented immigrant escape federal custody. She had broken federal law, Patel confirmed. She had interfered with an enforcement action. She had been arrested. Do Americans get to pick and choose which laws they follow? No. Does a state court judge get to decide she does not want to follow federal law? No. If you violate federal law, you get arrested. Patel confirmed each point. Kennedy named it directly. That is called equal treatment under the law. Patel confirmed it. Then Kennedy pivoted. Do you remember Lisa Page and Peter Strzok? Patel said yes. Kennedy walked through what the Inspector General had found. 2 senior officials, one at the FBI, one at the Justice Department, who the IG concluded had harbored deep bias against a sitting president and had actively wanted his opponent to win. Kennedy read from the record. An exchange between them, documented. Trump's not ever going to become president, right? And the response from a senior FBI official. No, he won't. We'll stop it. Did Kennedy read that correctly? Patel confirmed he had. Kennedy continued. Page had left before she could be fired. Strzok had been fired. They filed a lawsuit. Because in Washington, he noted, it is easier to divorce your spouse than fire a federal employee. And then he asked the question that changed the temperature of the room. Why did the FBI give Strzok $1.2 million and Page $800,000 to settle their lawsuits? Patel said he did not know. The settlement had been reached in the prior administration. Kennedy pressed. Who made the decision? The prior Department of Justice. Who in the prior Department of Justice? Patel said a settlement of that kind could only come from the Attorney General. Kennedy named the Attorney General. So the Attorney General decided to give Strzok $1.2 million and Page $800,000. After they were fired, after the Inspector General found they had actively worked to interfere in the 2016 election. Is that right? Patel confirmed that was his understanding of what had been agreed to. $2 million, taxpayer money, paid to 2 officials who had been removed from their positions after a federal inspector general concluded they had allowed personal political bias to infect their work at the highest levels of federal law enforcement. The settlement had not required them to acknowledge wrongdoing. It had not required them to return to the public record. It had simply paid them. And the Attorney General who authorized it had done so without, apparently, any public explanation of why fighting the lawsuit had been deemed more costly than writing the check. The legal mechanics of that settlement deserve attention. When federal employees file wrongful termination suits, the government has a choice. It can fight the lawsuit, present its evidence, defend its decision, let a court assess whether the termination was justified, or it can settle. Settling means paying money without a court finding that the termination was improper. It means the public never gets a judicial determination of whether the officials were rightly removed. It means the officials receive compensation without admitting fault and without the government receiving vindication. In this specific case, the Inspector General had already produced a public report concluding that both officials had allowed political bias to affect their work. That report was the basis for the terminations. Settling the lawsuit, rather than defending the terminations in court using the IG's own findings, meant paying $2 million to avoid the very proceeding that would have tested whether those findings were sufficient. Kennedy's point was not subtle. The government had the receipts. It chose not to use them. Kennedy did not need to editorialize. The arithmetic was the editorial. A state court judge who helped one person escape custody was arrested. Two senior law enforcement officials who the IG found had worked to stop a presidential candidate were paid $2 million. Equal treatment under the law had been the premise. The settlement was the evidence against it. Kennedy moved to the laptop. October 2020, shortly before the election. A newspaper published a story about influence peddling, sourced to a laptop. A few weeks later, 51 former intelligence officials signed a letter. Kennedy named some of them. Senior figures from the CIA, the Director of National Intelligence, the Secretary of Defense. The letter said the laptop story bore the hallmarks of Russian disinformation. It was circulated widely. It shaped how the story was covered in the weeks before the election. Kennedy asked Patel whether he remembered this. Patel said he did. He had been the lead investigator for the House Intelligence Committee during the Russia investigation. Kennedy noted the timing. The FBI had had the laptop for 10 months before the election. They had it when those 51 officials signed the letter. They knew what was on it. They knew it was not Russian disinformation. The Inspector General's report had confirmed it. Kennedy asked who at the FBI had refused to allow the Bureau to tell the American public the truth. Patel said he did not have that name in front of him. Kennedy said he wanted the name, not a division, not a department, a person, with a brain and a beating heart, as Kennedy put it. Someone had made a decision. Someone had access to the laptop, knew what it contained, and allowed the Russian disinformation narrative to stand while the election approached. Kennedy wanted to know who. Patel said he would look into it. The weight of that 10-month silence is difficult to overstate. The laptop arrived at the FBI in December 2019. The election was November 2020. In those 10 months, the Bureau had possession of material that, according to the Inspector General's findings, documented the very activities that the Russian disinformation letter was designed to discredit. When 51 former intelligence officials signed that letter, days before the election, with their names and titles attached, lending institutional credibility to the claim, the FBI knew the claim was false, not suspected, knew. The laptop was in their possession. They had had it for nearly a year. The decision not to correct the public record, not to say anything that would undermine the disinformation narrative, was not an oversight. It was a choice. Someone made it. That person has a name. Kennedy wants it. And Patel, the director of the FBI, sat in that hearing room and said he did not have the name in front of him. Kennedy said he would like a name, not a division, a person, with a brain and a beating heart. The laptop question and the settlement question are not the same question, but they point in the same direction. In both cases, the official account of what happened required the public to accept the consequential decisions. A $2 million payout, a 10-month silence, were made by institutions acting within their normal scope of authority, by unnamed officials following unnamed protocols, with no individual accountability attached to the outcome. Kennedy was pressing against that structure. Not with a document, not with a wire transfer confirmation, but with the simple demand that someone be named, that the institution produce a person, not a process. And then, without warning, Kennedy asked the question that none of the prepared answers covered. Did Jeffrey Epstein hang himself? Or did somebody kill him? Patel's response was immediate and rehearsed. Senator, I believe he hung himself in a cell at the Metropolitan Correctional Center. Kennedy asked whether Patel was going to release all the information about it. Patel said they were working through that with the Department of Justice. Kennedy asked when it would be done. Patel said he thought in the near future. Kennedy's response was brief and direct. Like before I die. Patel said they were working to protect victims while also not releasing information irrelevant to the public interest. The near future. They were working on it. Protecting victims. These are the phrases that have surrounded the Epstein case since 2019. The same phrases that have accompanied every partial document release, every delayed disclosure, every hearing where the answer to the most direct question has been a process description rather than a commitment. Kennedy had asked whether the man died by his own hand or someone else's. The FBI director said he believed it was a hanging. The cameras kept running. The stenographer kept typing. And the near future remained, as it always has in this case, at an unspecified distance from the present. Kennedy's follow-up. Like before I die. was delivered in the register he uses for observations that are too serious to shout and too important to soften. He is not a young man. He knows how long the public has been waiting. He knows how many times the near future has been invoked in relation to this case, across how many administrations and how many hearings, by how many officials who are working through it in ways that protect victims and avoid releasing information irrelevant to the public interest. The near future that Patel described has a particular character in the Epstein case. It is the near future that has been arriving since August 2019, when a man whose cooperation could have implicated some of the most powerful figures in recent history died in a federal facility where the cameras malfunctioned and the guards fell asleep, and the forensic evidence produced findings that a former chief medical examiner described as more consistent with homicide than suicide. That near future. The one Kennedy was asking about. The one Patel said they were working toward. Before he dies. What Kennedy built in that hearing was a portrait drawn in 3 strokes. The first stroke, equal treatment under the law, is the stated principle, but the principle has exceptions. Exceptions for officials who file lawsuits after the government finds they interfered in elections. Exceptions worth $2 million. The second stroke, the FBI possessed information before an election that contradicted a public narrative being used to suppress a story. The Bureau stayed silent. Someone made that decision. Kennedy wants the name. The third stroke, the most famous prisoner in American history died in federal custody under circumstances that remain officially unresolved, and the director of the FBI believes it was a hanging. 3 strokes. 3 unanswered questions of different weight and scale, but each one pressing against the same assumption that the institutions responsible for equal treatment, for transparency, for accountability, have been applying those principles consistently. Kennedy was not asserting they had not. He was asking the questions that would test whether they had, and the answers. Confirmed settlements, a name that could not be produced, and a near future that keeps receding, were the test results. The hearing moved on after that. Other items on the agenda. Other questions from other senators. But Kennedy had placed 3 things in the record that do not leave a room when the cameras stop. A $2 million payment to people the IG found had worked to subvert an election. A 10-month silence while the public was misled about a story the FBI knew was real. And a belief. Just a belief, offered quietly in response to one of the most direct questions a senator has asked a sitting FBI director, that the most consequential death in federal custody in recent memory was a hanging. Patel said he believed it. Kennedy asked when the information would come out. Near future, Patel said. Kennedy asked whether that meant before he died. The room understood what the question meant, not as a joke, as a measure of how long the public had been waiting, and how much longer the near future could reasonably be expected to last.